Continuing with our politics lead and what appears to be the most aggressive move yet in Special Counsel Jack Smith's rather aggressive investigation into Donald Trump's handling of classified documents. As CNN's Paula Reed reports, federal prosecutors have told a judge they believe there's evidence of a possible crime or fraud, and they need more answers from one of Trump's attorneys.
The Justice Department making its most aggressive move yet in its investigation into former President Trump. Prosecutors telling a judge they have evidence Trump may have committed a crime through his lawyer in an effort to compel Evan Corcoran to provide additional testimony to a grand jury about the former president's retention of classified material and alleged efforts to obstruct federal investigators.
They rifled through the First Lady's closet drawers and everything else.
Sources say in Corcoran's first grand jury appearance, he invoked attorney-client privilege to some questions. Investigators now want to ask him about all that led up to the FBI's search of Mar-a-Lago last August.
And even did a deep and ugly search of the room of my 16-year-old son, leaving everything they touched in far different condition than it was when they started. Can you believe it? The FBI and the Justice Department have become vicious monsters.
Investigators had subpoenaed any classified documents still in Trump's possession after he turned over an initial batch of government records to the National Archives.
They should give me immediately back everything that they've taken from me because it's mine. It's mine.
Corcoran helped to draft a statement attesting that there were no more classified records at Mar-a-Lago before the FBI scoured the Florida property and found hundreds more. Corcoran is one of 3 Trump lawyers who have gone before the grand jury.
What they did was to try and criminalize Donald Trump, as they always do. They found these 3 mundane statutes, espionage and the 2 others, obstruction.
Attorney Alina Habba took this stand in mid-January. Prior to the FBI search, Habba personally looked through several Trump properties, including Mar-a-Lago, for documents in a separate civil case against the Trump family business. Trump lawyer Tim Parlatore insists his client has done nothing wrong.
Nothing that we have found has any implications on him personally.
The special counsel is going to have another legal fight to get testimony from former Vice President Mike Pence. On a trip to Iowa today, Pence said he intends to fight the subpoena he received related to the special counsel investigation into January 6th. And Jake, he's relying on a novel legal theory to shield himself from testifying, but says he'll take the fight all the way to the Supreme Court.
All right, Paula Reed, thanks so much for that. Appreciate it. Let's get some additional insight now from former federal prosecutor and CNN senior legal analyst Elie Honig. Elie, what do these latest court filings tell you? Is special counsel Jack Smith going after Trump specifically, do you think, for obstruction of justice?
Yeah, Jake, I think there's no question now that Jack Smith is focused squarely on obstruction of justice. And I think even more specifically than that, we can tell that what really is drawing the most attention is this affirmation, this statement that Donald Trump's lawyers gave to DOJ last summer saying, we've now given you all the classified documents. It turns out there were many, many more classified documents. And I think DOJ is trying to figure out who made that statement, who made a knowing falsehood. And there's really 2 huge indicators here. First of all, when they got the search warrant to search Mar-a-Lago in the first place, one of the crimes they established to the judge by a preponderance of the evidence, not beyond a reasonable doubt, was obstruction. And now we know they're going to a judge saying we should get access to these attorney-client conversations because they related to a crime of obstruction as well.
Take us through the ins and outs of attorney-client privilege. What could Trump's attorney be forced to disclose if the judge goes along with this request?
So ordinarily, conversations between an attorney and client are privileged, meaning you don't have to testify about them. However, prosecutors can break through that privilege if they can establish that the conversations related somehow to an ongoing crime. Not talking about a crime that was committed in the past, but you and I as attorney and client are talking about something that is a crime itself. If you can establish that, then you can get access to testimony about what those conversations were. And of course, if that's the case, that'll go right to the heart of the obstruction issue here.
And how politically significant would an obstruction case be? Or might it add fuel to the fire of all these Republican allegations of the Justice Department being weaponized by the Biden administration?
So here's the real world dilemma that these prosecutors face. Ordinarily, if you're a prosecutor and you want to charge obstruction, it's the last count in the indictment. You charge whatever underlying crime and then obstruction into that investigation.
Right. Here's the crime, here's another crime, here's another crime, and here's all the attempts to cover up through obstruction.
Exactly. It's a kicker. It's an extra point
Right.
at the end. However, the law says you don't have to have an underlying crime. You can just charge an obstruction. The Mueller investigation, perfect example. Mueller said there's no conspiracy crime with Russia, but he suggested there could be evidence of obstruction. But we remember what the political attack was. Obstruction of what? So legally you can do that, but it doesn't carry as much force with a jury and I think politically as well.
Yeah, and then that's what we saw in a number of investigations that ultimately resulted in not guilty verdicts or that were thrown out to not much consternation. The idea that, oh, they lied to an FBI agent, oh, they weren't straight with, during the investigation. Not an actual crime underlying that, though.
Yeah, it's one of these issues where there's a difference between what the textbook says. The textbook says, yes, you can charge just obstruction. But when you're standing in front of a jury of 12 normal human beings, they're going to be thinking, okay, obstruction, but obstruction of what?
what? Yeah.
And it really undermines your case if you don't have that.